welcome to another American Bankruptcy Institute videocast. I'm John Hartgen, ABI's Public Affairs Manager. Our guest today is Bill Rochelle, ABI's Editor-at-Large and author of Rochelle's Daily Wire, available via ABI's online newsroom. Bill is in studio today and has just returned from observing the Supreme Court oral argument in the Husky International Electronics case, also known as In Re Ritz. It's a circuit split on Section 523 of the Bankruptcy Code and the question of whether a bankrupt individual must make a misrepresentation to a creditor before the debt held by that creditor can be non-dischargeable as the result of actual fraud. Welcome, Bill, to ABI's studio.
Good day.
What is your takeaway from today's oral argument?
Well, I tell you this, I very much miss Justice Scalia and his laser-like analysis of statutory language. It is remarkable how different oral argument is without him on the bench and without his insistence on a careful reading of the statute.
And why is today's case so important?
Well, in my view, it is beyond the mere question presented to the court in terms of actual fraud and denial of discharge. To my way of thinking, if the majority of the court come down and reverse the Fifth Circuit, to me, that is a ringing endorsement of an expansive reading of the equitable powers of a bankruptcy court, which, in my view, were undercut by the decision last term in the Law versus Siegel case, which, as I see it, really took away a large part of the equitable powers of bankruptcy judges.
And just hearing the proceedings today, can you make a guess as to which side might come out on top?
Oh, wow. I wish you wouldn't ask me that question because it is really difficult to guess how justices are going to vote based upon the questions they ask, because very often they are simply playing the devil's advocate. But my instinct tells me that the creditor got the better part of oral argument, and I'm kind of guessing that the Supreme Court is going to reverse the Fifth Circuit and not agree with Judge Carolyn King's opinion on the Fifth Circuit, and instead endorse the analysis that came from Judge Posner on the Seventh Circuit in the year 2000, in a case that people had almost forgotten about. And as I said, if that's the way the justices see the case, I think that's a nifty reaffirmation of the equitable powers of bankruptcy courts to build upon the sometimes, shall we say, vague language of a statute.
Okay, and now this is one of the first cases without Justice Scalia as part of the oral argument. Will Justice Scalia's absence have an effect on the outcome of this case?
Well, that's a very, very good question. And thankfully, we'll never know because he's no longer with us, so I guess I get a free shot at this one. But yes, I think it very well could, because he is such a strict, or was such a strict constructionist. My guess is that he would have been more prone to vote to uphold the Fifth Circuit decision by Circuit Judge King. So it's possible that the lack of him on the bench at least could make a difference in terms of whether or not there's a dissent. This is a case that possibly could be 8-0.
Gotcha. And in terms of timing on a decision, what sort of timing can we expect for the Supreme Court to make on this case?
Well, I think